Hello, it's Attorney Ashley Goggins here with another episode of Free Game Friday. You know what to do. Come on in, share this out with your family members, your friends, your cousins, your brothers, your boyfriends, your husbands, boyfriends, brothers, best friends, anyone that you know that may need this information. Let's go ahead and get this shared out, and we're going to get started in a few. I am going to share it out on my page. Please remember that you can always have your questions answered. I'll do my best to answer them live here every Friday for Free Game Friday. Just go to www.freegamefriday.com, submit your questions, and you'll have them answered. Okay, we are sharing this out. Just shared it on my page. Go ahead and do the same. Thank you guys for liking and commenting. Appreciate it. So today we're going to be talking about modifications of child support. This actually comes from a father with a 17-year-old daughter. So if you know someone that has a daughter that is, or a son, or any child that is coming up to the age of majority, which is 18 here in Florida, then they may need this information. So go ahead and share it out. Let me know where you're tuning in from. Thank you guys. I see you guys are coming on. We're talking about child support modifications. This particular instance, I'll give you guys a little bit more back detail about the question because it was a detailed question, but I wanted to condense the question down for purposes of social media. So remember guys that I am an attorney, but I'm not your attorney. This is just for educational purposes only. If you have a question, remember, go to freegamefriday.com and have it submitted. So this instance, let's get started. If you're just coming on, don't forget to share this out. So this is a husband. He's a husband. Him and his wife submitted the question. Essentially, the child is now 17 years old. The dad has been paying child support since birth. He's always been there for the child. He's provided for her in every way, shape, and form. However, he does not have a parenting plan or a time sharing plan. Remember that for later. He doesn't have a parenting plan. Obviously, he was put back on child support 16, 17 years ago, but he never received a parenting plan or established one through the courts, but he has been paying child support. The child is now 17. She is a junior in high school, and mom wants him to buy her a car. And because of the amount of child support that dad pays, he stated that he would not be purchasing her a car. Mom does not like this, so mom is now threatening to modify the child support and or extend the child support per the question, okay? Only can go based on the information that I'm provided with in the Free Game Friday submission. So that is the background of the story. That basically mom has gotten upset because he will not purchase a car from her for the daughter, even though he pays a substantial amount in child support. So first, to ultimately answer his question, is there anything he can do to fight the increase or decrease? So let's go back. Let's talk about modifications. So to get a financial modification, there has to be a substantial change in circumstances. That substantial change in circumstance means that there has to be a 15% difference or a $50 difference, whichever is greater, in order to modify child support. So for example, if dad is paying $1,000 a month in child support and mom is taking him for an increase in child support, the increase has to be at least $1,150. That's 15%. It has to be at least $1,150 difference. That means that their incomes have to have changed such that it changes the amount of child support from $1,000 to $1,150 when we put the numbers into the guideline calculation. So remember that we do child support based on a guideline calculation. The overall factors are basically the gross income that both parties make. gross income of both parties, insurance, retirement, mandatory union dues are small, but ultimately has the gross income changed so much that it will alter the the child support, provided that they don't have time sharing, because time sharing is a large factor in calculating that child support. And then if, let's just say, dad wanted to go get a modification. If dad wanted to do a financial modification, and this is a lower end, his modification calculation would have to come out to $850. So when someone is having a consultation with me and they want a modification, specifically modifications, I require a consultation, because I'm not going to take someone's money if I don't believe that they actually qualify for a modification. So I'll put the numbers in the child support guidelines and their calculations, and I'll say, looks like you actually might end up paying more while you're trying to get a modification, or it looks like you qualify for the modification. So that 15% difference, if a father was paying $1,000 per month, would have to be $850. So all I did was $1,000 minus 15%. That has to be the difference in order for him to qualify for a decrease in child support, okay? So that's first. So yes, it doesn't matter that the child is 17. I know that she's almost reaching the age of majority, but you can modify child support up until the child reaches the age of majority, 18. Once the child reaches the age of majority, then they're no longer a basis, but for a few exceptions that don't apply here. And you do get credit for the time of filing. So if you file 6 months before the child has reached the age of majority, you'll get 6 months credit for any type of difference. So if it's $100 difference, $300 difference, whatever the difference may be, they backdate it 6 months, and you'll either get credit for that overpayment, or it'll be added on to your arrears if there is an increase in your child support. I'm reading the question. If anyone has questions about the modification, please feel free to drop it in the comments, and I will answer the questions if you have any questions about anything I just said about the modification. So will you be able, the other portion of the question was an extension. So it depends on when the child support is ordered based on an extension of child support. That means an extension beyond the age of majority, so extension beyond 18. So in cases prior to 2010, some child support orders did not have a termination date, and it wasn't required by law. So you could be paying child support till the child is 21. You could be paying child support until you just stopped, or you said, hey, my child is grown, I need to stop paying child support. Some of them have no end dates, and so if you have an income deduction order, your employer could be taking the child support out of your check for forever, unfortunately, until you do something about it. So if you have a child support order that was prior to 2010 when the law changed, then child support can continuously be taken out because the law says they didn't require a termination date. Now, from October of 2010 to present, the current law states that there has to be a termination date. So generally you'll see where it says child support terminates when the child is 18, reaches the age of majority, is self-supporting, marries, dies, or graduates from high school, whichever occurs first. So in that situation, say your child is 18 years old, or she's about to be 18 years old, but she's still in high school. Her birthday may be late, or she's a junior, she failed. So you can qualify for an extension beyond the age of majority in that scenario if your child is 18 or about to be 18 but still in school and will graduate by 19, or will graduate when she is 19. You still would qualify for if you're a woman that needs a extension, you would qualify for that extension on the basis of your child reasonably graduating at the age of 19. So the new termination date would be on the day the child graduates at 19. Can't go beyond 19, and she has to actually be reasonably expected to graduate. Now, she's not doing anything in school, and she goes when she wants to, and she is not expected to graduate, or she has dropped out, then in that situation, you would not qualify for the extension. So in this scenario, if you're just coming on, mom is threatening dad because dad will not purchase daughter a car, and she is threatening to modify and extend child support. So the short answer is yes, she can do both under these circumstances. And I don't know what the incomes are, but she may go through the whole entire process, sit down, they calculate the child support, and based on your income may not be the same as it was 17 years ago. So it could be lower or it could be higher. But each year we have inflation, we have interest, everything changes. So it likely could be more or it likely could be less depending on what the incomes are. A lot of times when I'm dealing with fathers that never go back and seek a modification after mom has changed her whole entire life, she's no longer, really a child anymore. She has a job, she has a career. So the modification sometimes is not only in the best interest of the mom, but they could be in the best interest of the dad, because now mom is working, self-supporting, she's not destitute anymore, she's not making minimum wage. She may be a lawyer, she may be a doctor, she may be a nurse. Nurses make a lot of money, and a lot of times what may start off as a college student that was in school for nursing, 15 years later, mom may be making way more than dad. It happens a lot, but the burden is on the parent who needs the modification or wants the modification to go and apply for the modification. So if you do nothing, you're going to pay the same amount until someone does something. So if you never go and get a modification, you're not going to preserve your right to that overpayment that you've been paying for so many years, because there's been a change in income. Another thing that I see a lot is if you were put on child support when your child was 1 year old, and you're paying $1,200, $1,300 for child support, likely you're paying that much because, number one, your income, but daycare is expensive. So if you're paying $1,000 because $800 of it is going towards daycare, because it is a factor in child support, if you're going to keep paying and your child is in the 9th grade or in the 10th grade or even in 6th grade, then you're not going to get credit for that overpayment. That $800 can easily go down because the child is no longer in child support. But Department of Revenue is not going to be knocking on your door and say, hey, your kid he's an extended day now. He's no longer a 1-year-old, and you're no longer entitled. You no longer have to pay this amount in child support anymore. Why are you doing this? You can get a modification. So don't complain about it if you're not going to do anything about it. I always say when someone calls me and they say that they have like a 12-year-old, 13-year-old, and I look at the guidelines and it's still showing daycare on there and their child is like 15, I'm like, well, you've enjoyed paying this. Like, you like it. If you don't do anything about it, then you have no problem with it, is how I feel. Anybody have any questions about that? And I hope I answered this couple's question so dad can purchase the car if he feels like it'll be easier, it'll be an offset. I don't know. It would depend on this situation. So I'm not sure if that case is in Florida or not, but there is no case law in Florida specifically for this issue. It's still between the age of 18 and 19. Now, child support can be extended to infinity or forever if the child is disabled, but that modification or extension has to be done before the child reaches 18, and there's a whole separate process that's in place when you're trying to say that the child is permanently disabled and will forever be dependent and need child support for forever. That's a different situation. How to get child support license reinstatement during the virus shutdown. So we do Florida e-filing here. Even if you're not a lawyer, you still can sign up for Florida e-filing. You also still can go drop off or mail your petitions for what basically will be a motion to contest license suspension. If you Google motion to contest license suspension, you can fill out the packet. There is also a checklist on Duval Clerk that guides you through the process. You can mail it in to the family law clerk, or you can e-file it yourself. Lawyers are required to e-file, so the court being shut down does not really affect us with filing anything. Usually most pro se, meaning you don't have a lawyer, would go to the courthouse to fill out the paperwork, but you can still print out, if you have access to a printer, you can still print out the documents, fill them out. You can mail them to the clerk of court. Or you can sign up for e-file. You don't have to be a lawyer to sign up for Florida e-filing. You can file just like a lawyer can file, and it's free to register for Florida e-filing. The process is still going to be the same. You're going to serve the Department of Revenue. You're going to serve the mom the petition to, or the dad. I don't know if Keenan is, I believe that's the male. But the process is going to be the same. And in Duval, we really haven't, nothing's really slowed that much on our end. Everything has just gone virtual. We're having, one of my clients actually having a motion to contest his license virtually. Okay? All right, guys. So again, if you guys have questions about anything, go to freegamefriday.com and submit your questions, and hopefully they'll get answered live here on Free Game Friday. If you are watching the replay, go ahead and share this out. I appreciate the love, and I will see you guys again next Friday. Bye.